common question we get in our office is just what is the difference between joint tenancy and tenants in common when it comes to holding property? Now, both of those refer to what is called concurrent ownership, which just means two or more people holding property together. But each of them do carry very big differences when it comes to what happens to your interest in your property after you pass away. For instance, does it lock your family into going to probate in order to clear the title of that property? Or do they get to just file one deed with the county recorder? Keep watching the video and we'll find out. Hi, my name's Andrew Bethel with the Bethel Law Corporation, and today we're going to be discussing the differences between joint tenancy and tenants in common when holding property with other people. As I mentioned before, they do carry big differences when it comes to what happens to your interest in the property after you pass away. But before we get to that, first we need to talk about concurrent ownership itself a little bit, and then we'll go into the details of each of those, that is joint tenancy and tenants in common. Then finally, I'll discuss right of survivorship, which is the big difference between the two. So firstly, as you can probably guess from everything I've said so far, concurrent ownership simply refers to two or more people owning real property at the same time. There are different manners and different ways that people can hold property together, but the two most common and most popular way that people do hold property is in joint tenancy and tenants in common. So firstly, what is joint tenancy? Joint tenancy is two or more people holding property at the same time with a right of survivorship created by an act of the parties, and it requires a unity of possession, interest, title, and time. Now I just threw a lot of things at you, but let me break them down for you. So firstly, right of survivorship. What that means is upon the passing of one person, their interest in the property automatically goes to the other person. So an easy example, and the way that we see it 90% of the time, is property held in joint tenancy between spouses. So for instance, a husband and wife, a husband owns the property in joint tenancy with his wife, but the husband passes away. In that instance, the husband's interest in the property automatically becomes the wife's interest in the property, and she becomes the sole owner. Now, as I mentioned before, two or more people. So you could have an instance where, for instance, three siblings own a piece of property together as joint tenancy. One holds 33%, 33%, 33%, so 1/3 each. If one of them were to pass away, their interest automatically goes to the other siblings, and those two now own 50% each. So that is right of survivorship, and I'll touch on it again a little bit later in this video. Next, it requires an act of the parties. And all that really means is that joint tenancy cannot be created by operation of law or something happening automatically. So for instance, if you inherit property through a probate proceeding, that's going to be an inheritance. You aren't participating or a part of the act granting you that property. So you're not going to be receiving that property as a joint tenant with anyone else who might be receiving the property. You're likely going to get it as a tenant in common, which we'll discuss in a few minutes. Next, there was those four unities that I mentioned: possession, interest, title, and time. Possession just means that everybody who owns the property has an equal right to possess the entire property. What that means is I'm not restricted to, let's say, this corner of the property over here and the other person gets the other corner over there. Each of us has a right to possess the entire property. The other is a unity of interest. Each of us has the same interest in the property. So for two people, that'd be 50-50. For three people, 1/3 each, and so on. That means you cannot hold a property in joint tenancy with someone else, yet having unequal interests. So for instance, I can't hold 60% and another holds 40. It has to be equal. Now the other two were title and time. Time just means that you and the other co-owner received your interest in the property at the same time, and title means you received your interests in the property from the same source. So two people can receive property at the same time, yet from different sources For instance, one inherits the property and the other is gifted the property, and all these things happen at the same time. Well, if those interests in the property didn't come from the same person, which they wouldn't have because of an inheritance, meaning somebody has passed away, meaning they cannot have gifted the property, then those people receiving it don't have a unity of title, meaning they cannot hold the property as joint tenants. Next, we have tenants in common, which is very similar to joint tenancy, but does carry fewer restriction and one big difference. So firstly, tenants in common requires an undivided interest in the property, just meaning that you and whoever else owns the property both currently own the property. Now this holds true with joint tenancy, but is something that is specifically called out when you read up on definitions for tenants in common. All that really means is you have to have a present interest in the property, not an expected interest down the line. Now the big difference is that tenants in common do not have an automatic right of survivorship. Remember, joint tenancy does, tenants in common do not. So that means when one person dies, their interest does not automatically go to the other holder of the property. Now we'll go into those details here in just a minute. The other small difference between tenants in common and joint tenancy are those unities that I mentioned. Remember, joint tenancy required 4, tenants in common only requires 1, a unity of possession. That just means that everyone who is on title to that property each has an equal right to possess the whole property. Again, not an instance of I can only have this corner and that person gets that corner. Everybody on title has the right to possess the whole of the property. But there's no unity or requirement for a unity of interest, meaning people can have unequal interests, such as a 60-40 split. There's no requirement for a unity of title, meaning they did not have to receive the property from the same source. And finally, there's no requirement for a unity of time, meaning parties could have received their interests at different times. Finally, we have the subject of right of survivorship. That's that big difference that I've been hinting about throughout all this, and I've kind of touched on here and there, but how does that really play out in the real world? So, as I mentioned, joint tenancy carries that automatic right of survivorship, while tenants in common does not. That means if you hold property in joint tenancy, the person who passed away, their interest automatically goes to the other person. But in tenants in common, that isn't present. So what that means is if somebody owns property as a tenant in common and they pass away, their property does not, their interest does not automatically pass to the other holder. It actually goes down into their estate. Now it's their heirs' property. What that means and what the implication is, if somebody does hold title to property as a tenant in common, their family might be bootstrapped into having to go through a probate. So we won't go into probate in detail here. You can watch our presentation on estate planning given by Dale Bethel on this channel if you want some more information about probate. But in general, if there is property that is held by a person who has passed away as an individual, then they are no longer around to sign a title change on that property. What that does is create a cloud on the property, and you need a judge's order to clean up that cloud. So in order to pass clean title to that property, you go through a probate court. So if somebody owns even a portion of a property, for instance, as a tenant in common, and they pass away, their property now goes to their estate, and in order to do anything with it, for instance, sell the property, even refinance it, the family has to go to a probate court and get a judge's order to pass clean title to the property. Now that carries automatic fees and a long delay period. So if you do hold title as a tenant in common with somebody, that is not a way to plan one's estate if you plan on your heirs receiving that property. Thus, even if you have a portion of an interest in a property, you can still put that portion into a trust and have your trust say who is to receive it, and now your family is not required to go through the probate, and they don't have to wait all the 9 to 12 months it takes to go through probate, or pay for the many upfront fees that are required for a probate. At that point, the family just files one deed in order to remove your name from the property, then one more in order to transfer the property to the beneficiaries. So, in summary, joint tenancy, the big difference between that and a tenants in common is that right of survivorship. Joint tenants, if one of them passes away, the other party automatically gets that half of the property. Tenants in common, if somebody passes away, their interest to the property goes down to their estate, meaning their heirs are going to have to go through probate in order to actually clean up the title to that property. Now, one last thing that's cropped up a couple times, but is something we do have to consider, is what if a deed is silent? What if it doesn't say joint tenancy or tenants in common? What happens there? So, although we've been talking about probate this whole time, this is actually a little bit of a strange instance where we have to go to the California Civil Code to find out what that property is being held as. So, where a property is granted to two or more people, but does not say whether it is held in joint tenancy or as tenants in common, the California Civil Code presumes or automatically says that that property is held between those parties as tenants in common. That's the default, meaning that if two people inherit property, but the deed is silent as to whether it's joint tenancy or tenants in common, then the California Civil Code says that that property is held as tenants in common. And as an additional note to that, if the deed does not say what those parties' interest in the property is, for instance, it just puts two names down, it will be presumed to be an equal interest in that property. So if it's silent, each party gets 50-50 if there's two of them. Now, that presumption can be rebutted with some evidence that there was an intent to give parties an unequal granting of the property, but you cannot get around that tenants in common requirement. So, at the end of the day, if you do own title to property with other individuals, you do want to check that deed to make sure it at least says joint tenancy. If it says tenants in common, now you have to think, tenants in common means probate. If I die, my interest goes down to my heirs, but they have to go through probate court first. In order to avoid that, you can put your half interest to the property into a living trust. Now the property is held in trust, family does not have to go through probate, and they just do a couple quick deeds filed with the county recorder in order to pass title to that property down to the next generation. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.